Good morning, everyone, and thank you for attending this taster lecture. We have about 55 minutes. I know that we are expecting a few more people, but we're going to start at 11 o'clock as planned. Just a few things before we actually start. First, let me introduce myself. My name is Noam Shemtov. I am an intellectual property and technology lawyer. One of the things that I do in the LLM program is I convene the IP creative industries, IP in the creative industries module. And what you will be getting here today is a little bit of a taster of the kind of things that I will be covering next year. I'm also the director of, the deputy head of the Center for Commercial Law Studies. If you have any queries on a more general basis, of a more general nature, hopefully I will be able to answer these as well. One more thing, first, any questions, please put in the question and answer into the question and answer box. And like this, if we finish a little bit before time, I'll be able to address some of those issues. I don't expect that we will have much time. I mean, this is an area which in my module I cover. I spend quite a few hours and some more in order to look at. Another thing that you need to bear in mind is that the platform that we are working with now, which is Zoom, is not the platform, is not likely to be the platform that we will be working with when we start next year. So those of you who join us are likely to work on a different platform, but more on that when you actually join. The Zoom platform is a teaching tool, has its own limitations. Obviously, we are doing it now because you do not have an account with Queen Mary, and it's something that is accessible for everyone. Hence, the choice for Zoom, the choice of Zoom for this particular purpose, and that is, those pre-studies encounters. So, I assume that the audience is mixed, and we have people with some experience in IP copyright and some that do not have it. I will try and pitch it at a level that would make sense to most of us, if not all of us. So let me just share my screen with you. Yeah. So. The topic of this taster lecture is, if you would like, the impact, leading the title, the impact that the emergence of the AI technology has on the creative industries in the context of IPRs, intellectual property protection. That is not an esoteric area. That is not something which is relevant in particular to people who are in research or technology geeks. As we shall see, AI is taking more and more of a dominant role in, if you would like, creative processes, in a variety of creative processes in various sectors amongst the creative industries. So before we actually start and look at those examples, it is important to bear in mind that central to the copyright system, the copyright framework, is the concept of author and authorship. If we look at the way authors have been dealt with in the past, whether we look at some Asian cultures, whether we look at ancient Greece, and whether we even look at medieval Europe, authors were not traditionally considered to be the owners, the proprietors of the work. They were considered to be, to an extent, any changes according to culture and tradition and period, as vessels, as vehicles, as pipes, if you would like, of transmitting knowledge and memories, either from earlier days or from, well, if you would like, medieval Europe, from God, right? So a mere intermediary between God, who is the source of all knowledge, and the people. It is only when we started to move towards modern times where we started as a system, as a legal system, to consider the concept of authorship in relation to proprietary interest. So if I generated it, if it originated from me, it means that I have, in one sense or another, an exclusive right over it. And it is this concept that today, to an extent, as we shall see, is challenged by the emergence of AI technology. It is this nexus between the author and the output that makes it, and we shall see to what extent and if at all, makes it tricky to assess or to examine works where AI, in which AI was, in the creation of which AI was heavily involved. By mere coincidence, it is the jurisdiction, the country in which you are interested, that is the UK. This, I guess this is why you are here listening to this presentation, and the one from which I'm speaking to you, that has a fairly unique provision which is relevant for our purposes. When looking at the concept of authorship, as we shall see later on today, the UK has came up with the concept a long time ago of computer-generated works when no human authorship is involved. You may think that is fantastic, that this is fantastic, that UK legislatures and policymakers were proactive in relation to advanced technologies such as AI, and actually made a policy, an informed decision in relation to such policy questions. And we shall see that it's not necessarily so. And the UK stance on this question, on this issue, is far from clear. And definitely, and I can say that with confidence, is completely unintended. When it comes to civil law countries, right, and civil law countries, civil law systems, whether we're looking at the German model or the French model, it is very clear that when we are looking at the concept of authorship, if not explicitly, then implicitly, we are looking for a human. Right? We are talking about the work of the mind. We are talking about an author who is a creator of the work. Reference to intellectual efforts and at EU jurisprudence, all of those concepts, at least implicitly, suggest a human author. And those of you who have done covered other IP rights in your careers or in your studies, are probably aware that unlike, say, patent law, where really a key issue is the output. We look at the output, we look at the invention, and we ask, in relation to it, we look at its merit, and we ask whether it has the relevant merits. Is it inventive? So does it involve an inventive step? Is it novel? And so on. Copyright is not, works in a different way. It is not the output which is relevant. It is actually process focused. It's the way in which the very thing, the copyrighted work, was created, which plays the decisive role. The output is of little consequence. I mean, I can write now a poem, and trust me, it would be absolute rubbish. I wouldn't know even where to start. Nevertheless, it would attract copyright protection. Because what is important is the fact that I actually did it. I can write a piece of computer code. And again, based on my particular skills, it would be fairly basic. Actually, not fairly, it would be basic. Nevertheless, it would attract copyright law, because it is the process that matters. The fact that it can be simple or rubbish is completely irrelevant. Hence, again, in the context of copyright law and AI assisted processes, there is a particular challenge when it comes to copyright. Now, sorry, I think we need to go to, I didn't start with the slideshow, did I? Here we go. Sorry, I think now it's better. Here we go. So, just here. Yes. Now, what is copyright stance in relation to non-human authors, therefore? When it comes to copyright, even common law systems, such as in US, some of you actually may have followed it was a few years ago, the selfie, the monkey selfie story in the news. And when it came before the US Copyright Office, it agreed that works created by animals are not entitled to copyright protection. It was not the photographer itself who gave the monkey the camera and possibly trained the monkey, if you would like, by having the monkey viewing the process of taking a photo again and again by the photographer. That was not enough. The photographer was not the author. Neither was the monkey the author, if you would like, because there were various claims made by various charities, charities for the welfare of animals, that said, look, it should be the animals, and we can actually handle the right on behalf of the animal for the benefit of animals as a whole. The US Copyright Office said, look, all of that is contrary to the concept of a copyright. When we talk about copyright, there has to be a modicum of creativity. Creativity is professed by a human author, and that was the end of it. The UK, as I said, has this. The US does not, and neither the majority of jurisdictions around the world has this peculiar provision that states that in the case of computer-generated works, the author is the person who made the relevant arrangements. Now, who is the person who made the relevant arrangements that were necessary for the creation of the work? That's a good question in its own right. But later on today, we would look at whether this provision actually makes sense and what is a British court likely to make of it. Should it come before it? Should a dispute in that context come before it? I'll give you my best prediction. So, where are we now? I'm not going to spend much time. Again, time is of the essence in our case. I just want to give you a full picture as much as I can by focusing in particular on the important issues. There were various industrial revolutions throughout the years, the last few centuries, and indeed in each of them, we saw that rather than taking our intellectual property model and checking it out of the window because it doesn't fit, because the rules of the game have changed, our intellectual property model proved quite resilient. Yes, it needed various tweaks and adjustments, but it continued to function, and in a lot of cases to function pretty well. And when it doesn't function well, it's not necessarily due to those adjustments that were made, but depending on the case in question, due to various other factors. Okay. Now, let's think about intellectual property and what does it mean. Now, again, when we run our classes on that, we spend quite a lot of time, but rest assured, nobody needs to be tech savvy in order to get it. The definition and the discussion that we will have in class would be by lawyers, for lawyers, so you would understand how it actually works, also for the purposes of today. in order to understand the legal concept and processes, rather than having an in-depth technological understanding, which is not necessarily required for the purposes of our present legal analysis. So for our purposes now, it's comfortable or it's convenient to think about the various stages of AI in the following manner. You can have just artificial intelligence, sometimes referred to as narrow AI, which is what we have today and at present. You can have people refer to AGI, artificial general intelligence. This is where an AI system can perform tasks on par with humans in terms of cognitive performance. So cognitive computation, if you would like. This is something that if and when we reach, it's going to take some time, depending on who you ask. You're going to get a different answer, whether it's around the corner, whether it's a decade, whether it's half a century ahead of us. But cognitive computation is not here. And it's probably not going to be here for the next a few years at least. Artificial superintelligence, I think this is it's safe to say that this is clearly within the realms of science fiction rather than science. Any intellect that greatly exceeds the cognitive performance of a human being. Yeah, those of you familiar with science fiction, yeah, it's the kind of stuff that you would probably see in an Isaac Asimov book from the 80s. But it is not to say, of course, that you know, it's if it's in science fiction right now, it will stay in the science fiction forever. I mean, yeah, Pliny the Elder, how much has been considered impossible before it has been done? Nothing is completely impossible in this context. So indeed, the industry may develop to such a stage, but there is no point of us, unless it's imminent, tweaking or changing our IP in relation to a change that may come, but when, if, and to what extent, it's far from clear. So, and I'm emphasizing these points because you tend to see, especially by some, let's put it like this, colleagues of mine, so legal jurists, sometimes you see that science, or you notice that science may mix with science fiction. People are referring to abilities and capacities that are simply not there and are not likely to be there in the near future. And on the basis of this, are making suggestions and proposals. It's useful to keep both feet on the ground in this sense, and actually listen to what the scientists themselves say as to what the systems, those systems are capable of. And are not capable of. Let's start and have a look at how does the technology play? How does it play out in the field of art? And I'm going to give you a number of examples, and it is important to bear in mind when we look at these examples. That it is one thing for AI to play a role, an important role, a crucial role in creative processes. It is a completely different thing for it to be involved to such an extent when you say, when you may say, look, there is no human author. It is only the machine. It is the second one of those which poses the biggest challenge to our copyright law. Now let's have a look, and I'll focus in particular on the first example. Now I don't know how many of you actually, let me lift my photo here, are actually familiar with that particular example. The portrait of Edmond de Bellamy from 2018, produced by a French art collective calling itself Obvious. It's basically three three software designers from France. It was described by Christie's, it went on sale at Christie's, described by Christie's as the first AI-produced portrait. I mean, it has a nice cachet to it. Estimated price was $9,000 US. It was sold to 2018 for $432,000 US. How was it created? Again, without going too much into the science behind it, the key here, so what you have here is probably the most talked about branch of AI, deep learning, and GAN, generative adversarial network. So how does GAN works? What you have here essentially is two algorithms, competing algorithms, the relationship between which is defined by our software engineers. Those two algorithms, one is referred to as the generator, the other is discriminator, are basically testing one another. The generator creates new images by trying to fool the discriminator into thinking that the generated images are actually real. Now, how does the generator produce those images? By being fed previously with a large amount of data, various data sets selected by, in that case, actually, by those software engineers on the basis of various variables, right? So you would say, well, I want something that would be based on, and we mix styles between the 16th century and the late 19th century. And so what you do is you would feed, according to various parameters, you would feed you would feed the GAN system or arrangement with data being portraits properly formatted from the 16th century to the late 19th century. At the end, you're happy with the result that you get, and then you basically upscale the resulting image with an upscaling algorithm. You print it with a jet ink printer, and hey presto, you have the final result. So just to cut a long story short, this was generated by AI, and Edmond de Bellamy never existed. There wasn't such a person, there wasn't such a family. Actually, there was a number of portraits of the imaginary Bellamy family that was produced, right? This is all made up, all created by with the use of this generative adversarial network, the GAN. If you look carefully at the bottom of this portrait, you would see that rather than the signature of the traditional signature, you have a mathematical formula. This is a mathematical formula that describes the relationship between the two algorithms that I've just described to you. So it was quite sensational at the time. It was produced, sold. Everyone was happy as far as we are concerned. But where does that leave copyright law? So, you know, there is no dispute in that respect, and copyright law doesn't have to kick in and to be engaged. But where does it leave copyright law? Who is the author of that thing? What are they to do if tomorrow I'm looking at it online, I reproduce it, and let's say I start to produce, say, wallpaper with the photo, the image of Edmond Bellamy, postcards, posters? Who's going to sue me? And for what? And what if I argue in return? There is no copyright because there's no human author. And if there's no human author, there can be no copyright protection. So you see the kind of questions that those advancements in technology can give rise to, and why it is important to have a clear policy or a clear position in that respect. Because if we don't, there is lack of clarity. If I am here, if I am planning to invest in such a process, and such a process would obviously take time, money, expertise, and I know that possibly my work can be taken and utilized with impunity by third parties who did not engage in the processes I did not incur those expenses, I'm likely to think twice whether it makes sense for me to do so. Okay, so a few more examples, and I'm not going to do or give you the same example, or the same lengthy explanation here. Robbie Barrett, AI-generated nude portraits again. I personally find it somewhat disturbing, especially the one on the left, but at least it is interesting. Here you go again, nude portraits that were fed as data sets to those algorithms with various variations introduced, and you can see producing this type of works in 2018. So AI generated new portrait. Again, where does copyright law stand in that respect? Napoleon Bonaparte. Again, the more you look at this, the stranger it is. Again, AI-generated portrait. Google Deep Dream. So Google AI system producing that allegedly without any human authorship involved, possibly. It's good to remember that is not something that is happening only in the last few years. I mean, those AI-generated works, if you would like, started a couple of decades ago with very primitive AI arrangements. And again, whenever there was, because the number was small and they were very rare, I mean, in the end of the day, in order to understand where does copyright law stand in that respect, you probably need to have a dispute, unless you have a very clear piece of legislation. It needs to come before the courts. The court needs to consider the legislation, needs to consider the jurisprudence, and need to come out with a clear decision on where does the law stand in that respect. So the example here of Aaron being the name of the AI employed by Harold Cohen, the British artist, as early as 1995. You can see here the first color image created by Aaron, the Computer Museum in Boston. As I said, as early as 1995, here you can see Harold Cohen actually engaging in the actual print of the work, which was produced, generated by or with the assistance of Aaron. And I think those variations and nuances in terminology play a very big role, or may play a very big role in any determination under copyright law. So summing up the situation of the picture when it comes to the art world, and again, these are just a few examples. This is a taster lecture. AI is involved, heavily involved, to an extent, or arguably involved to such an extent that maybe one, in some cases or instances, cannot identify a human author. If AI involvement is so significant that, if you would like, it severs the nexus between, which not needs to be direct, between the author and the output, then you don't have a human author. You have people that invested, worked hard on tweaking a relationship between algorithms by choosing data sets. But can you say in a copyright sense that these people are the authors of the resulting work, the output? That is a different matter altogether. And what makes it even more tricky in the case of AI technology is that when it comes to deep learning, there's a concept which is known as explainability. Even the person that was responsible, I mean, many times it's various people, but let's say that we have one person, just to make it easier, that was responsible for all the various stages. So the same one person came up with the algorithms, defined the relationship between the algorithms, defined the data sets that need to be fed into the algorithms, actually fed those data sets onto the GAN arrangement, and as a result tweaked and retweaked the relationship and the data chosen so the output would be to his or her liking. Even such a person, when looking at the final result, would find it very often impossible to explain how come the AI came up with that particular output rather than with a number of other alternatives. I mean, that's the way the technology actually works. And when that is the case, and when the author has been removed to such an extent from the final output, there's a good case, there's a good case to argue that you may not have a work with a human author. The question is, where does copyright stand in that context? We'll get to that very, very quickly. I'm going to go now, or go very quickly through, I think it was illustrated through art. I'm going to just give you a few examples, just to give you the flavor of things, that this is not specific or unique in the field of visual art. Okay, so actually, before we start, one more point to make. It is important to remember, I made a distinction at the beginning between copyright and patent law, how patent law is very much dependent on the final output, and how do we assess the final output in order to find whether protection should be granted, whether the output, the invention that is novel, and does it involve an inventive step, and so on, and how copyright is really about the process. If we are looking about the product rather than the process when it comes to copyright, I think there would be no question whatsoever. In many cases, the product itself would be considered as art by a lot of people. And there were various tests that were run in various places around the world, right? Human subject tested by Rutgers AI lab, for example, considered when they were given sets of works produced by AI or with the heavy involvement of AI, and some produced merely by humans, no AI involved. Interestingly enough, it's the ones that were AI related, which was considered to be the more art-like by human subjects. So when it comes to the final output, it's fairly clear that there is, and there probably no distinction in terms of the the art-like qualities of it when compared to works produced by humans. It's the process that we need to focus on. Literature, again, very quickly, there are various examples out there, and again, I'm not going to spend any time on it. Some of them go as early as 3 decades ago and even more, to works that were produced by algorithms, by deep learning systems. I mean, the more primitive ones are less impressive, but if you look at some of the newer ones, actually various literature competitions around the world allow, in terms of entry, the entering of works that are not produced by humans, and when you can actually keep that fact hidden, strangely or not strangely, some of those works actually passed a few stages before they were chucked out by the deciding panel. So they have the relevant merits to an extent when it comes to literature, and it is happening as we speak, exactly as in the field of art. An example to a poem. When it comes to music, I think you can see quite a lot of things happening in that respect. I assume possibly some of you are actually aware of it. Go on Google, onto Google, and just put AI produced music, and you will get fairly large amount of examples out there. IVA is quite an interesting one. First virtual artist to have creation registered with the Authors' Right Society, CESAM in France. Right? So, again, when does copyright stand in that respect? Again, it is important to distinguish between works that are produced or generated by AI purely, similar to the example that we had with Edmond de Bellamy. So parameters decided upon, data being fed, and the output produced by AI as is then offered as a work. On the one hand, and on the other hand, where AI is being used as part of the process, but you have heavy involvement also of humans. So, for example, have a look at IBM Watson and Alex the Kid, right? So the music is produced, if you would like, jointly. So you are an author and you are being assisted by an AI system. Here, I think the picture is clear. This is, although if that was not an AI, even if it was a person, arguably you could have had a work of joint authorship, right? In that case, Alex the Kid and that person. When you don't have a person, when you have an AI, you still have at least one identifiable person as an author in the process, Alex the Kid. And when that is the case, this is not an authorless work. We know where the rights sit in that respect. You have a variety of other examples out there when it comes to music and AI. Films are, I think that in the case of films, you do not have, to the best of my knowledge, any commercial products out there that are purely the result of AI systems. Yes, various things happened lately. For example, the first cognitive, as it is called, movie trailer by IBM's Watson. So what you really had here is IBM Watson, rather than pilot groups of some sorts, IBM Watson choosing, according to various parameters, various scenes that it considered, if I may say so, to be suitable for a trailer, and those scenes were then brought before a human actor, right, the editor, in Fox 20th Century, that decided what is going to make it to the final cut and how. Nevertheless, you have a quote here that the AI involvement and contribution was instrumental, gave them new insights, if you would like, to how a trailer may look like. But here, I think less controversial, AI, very sophisticated tool, but nevertheless, a tool and a tool only. Fashion as well. Again, I'm not going to spend time. Marchesa, I think, is one of those actors that is using AI quite heavily in relation to some of its haute couture products. Jason Gretsch, South African fashion designer. He has what is called his cognitive couture. Looking at all those examples, it brings us to towards the end of our very brief discussion here. Who is the author? Who is the author, right? So if we look, well, at what this gentleman, for example, said, just a bit here, what this gentleman said, which is, so Immanuel Kant or George Wilhelm Friedrich Hegel, the German philosopher, was talking, like Immanuel Kant, talking about the nexus between the authors and the author's personality and the output. I believe that the picture is fairly clear. When it comes to, I mean, you have various questions in that regard, but I think what we should ask ourselves is, does works of the nature that we looked at, brief, do they count as a copyrighted work? A work that should be protected, is protected by copyright? If yes, who is the author? If no, the next question is, should they count as protectable copyrighted work? If we say that yes, then again, the question is, who should be the author? If the answer is no, they shouldn't, that what is to become of the output that is generated in that manner? As you can see here, those conversations are also intermingled with larger questions, for example, about electronic personhood. Now let's think. Does this count as a copyrighted work? I mean, let me kill the suspense right now and tell you that I have little doubt that if it is a work where no human author could be found, it's beyond doubt that if we are looking at civil law systems, there can be no copyright protection. And if there is no copyright protection, then as far as copyright law is concerned, well, there is no protection. Going back to my example before, to my hypothetical question, yes, then someone, as far as copyright law is concerned, can go, can copy, can utilize with impunity as far as copyright law is concerned. Is that really desirable? That's a different question. Could you do something else? Maybe, depending on the question. Sometimes unfair competition law may kick in, depending on the jurisdiction and the particular circumstances of the case, but that is not really satisfactory. When you go to common law countries, again, I think the answer would be quite the same. If we look at the US, we saw the monkey selfie case, and the answer would be similar in the case of AI. The Copyright Office was quite clear, and I'm pretty certain that the case would be exactly the same if it would be tested in various instances in the US. No human author, no copyright protection. What about the UK? Remember what we said. The UK has this peculiar provision that deals with computer-generated works. And I said that it's far less glamorous or promising that it looks at first sight. Two questions to consider in that case. It tells us that the author is the person who is responsible for the arrangements. First of all, this also brings his own set of difficulties with it, because in the case of, say, deep learning GAN type of arrangement, who is the person responsible for the arrangements? What type of arrangements that make the whole thing happen? Well, many people made the whole thing happen: the programmer, the user, the person who sells the software, the person who comes up with those algorithms, the person who is the data trainer. Are they all to be considered as authors, as joint authors? And let's say that we settled that question, so we know who is the author. Do we have copyright protection? Remember, in order to have copyright protection, one of the qualifying criterions is the work needs to be original. Now, what is original? What does originality mean when it comes to UK law? Well, that depends now, still, Brexit notwithstanding, on the jurisprudence of the Court of Justice, the European Court of Justice. And the jurisprudence of the Court of Justice of the European Union state that it needs to be the author's own intellectual creation in order to be original in a copyright sense. Again, I'm running a bit with my words because I'm very conscious of the time. I'm looking here all the time. So if that's the case, even if I identify the author, can you say that it's that the output is the author's own intellectual creation? The person who, say, the programmer, is Edmund Bellamy his own intellectual creation? I think I would argue that it is not. It results from it, but his own intellectual creation are those algorithms and the relationship between them. As a matter of fact, if asked to explain exactly how Edmund Bellamy, the portrait, the image, the exact image resulted, they are not likely to be able to do so. I referred to it before as the explainability principle or concept in deep learning science. So you're likely to have also problems, in my view, when it comes, if it was to come before a UK court. What's the result? Well, what should be the outcome? Well, if that's the case, if there is no copyright protection, should there be copyright protection? Well, you may say that copyright protection should be considered, and it should be granted in relation to either the people that are responsible for the work or to the arrangement that I just described. Some people argue that it should be granted, authorship should be granted to the AI system itself, and when it comes to ownership, it's the people behind the AI system. That, in my view, and again, we will spend much more time next year looking at that, makes very little sense, because the concept of electronic personhood, like corporate personhood, there is no legal personhood associated with AI systems, notwithstanding various, I won't even call it initiatives, but tips that were done in that respect. Just no need for it for the time being and for the foreseeable future. So what is to become of something like works like Edmund and Bellamy, considering or assuming that indeed there is no human author? Should he just let it lie, like quite a few people advocate, play in the public domain because no human author was involved? I personally don't think that that's a good idea as well. If we look at what is it, I mean, authorship requires a relationship between the author and the work, and that clearly does not exist here. But that does not mean that it should not be protected. If we think about what is it that we're really trying to achieve, what we don't want to happen is the work falling into the public domain and people, like the example that I gave before, copying it and reproducing it with impunity. So what we want to protect is the investment that is made in the creation process in order to incentivize further creation in that respect. Have more Edmond de Bellamy's and other types of works, whether it's music, art, and what have you. And if that is the case, what we do have is a system or a modality that works pretty well in relation to other types of works where no authorship in a copyright sense could be identified. For example, sound recording. If you would like the creation of a new category of works that can be protected under copyright law, but not copyright, but what civil law countries would refer to as neighboring rights or related rights, this category was created exactly for that purpose, to protect the investment behind the production, say, of an album. Who is to enjoy this new right? The producer, the person who actually took the risk in putting that out there in the market, because that's what we wanted to incentivize, the creation of further works in that respect. And therefore, if copyright law is to be tweaked, one thing that can be considered, and I'm getting into that here at the end, is possibly the direction in which Japan is going, and that is to possibly create this type of category of works as a related right or a neighboring right type of category. But the only way in which this can probably make sense is for it to be accepted worldwide, or almost worldwide. In the end of the day, copyright law is one of those areas of law which is to a not insignificant extent harmonized across the world. And if it is to make sense, other countries and all, or at least most legal systems, need to follow the same path in terms of defining what is it you would like to protect against what, and come up with the best tool in that respect. Again, in my personal view, a related right type of a category would make most sense. And with this, I hope you lasted until the end. I would finish. So let me just go here and have a look at whether you have any questions. So anyone who has any question can fire away now, but we have one. I have one before me. If AI is provided copyright protection, who can sue on behalf? Well, that's exactly the case. If it's not about AI being granted protection, but are we likely, or would we like to grant protection in relation to works generated by AI? And if so, who would be the beneficiary? If we are to follow the related right model that I was referring to, then it would be a person making the arrangements that are necessary for that to happen. Now, I just explained before that this can be a tricky question. Yes, it is a tricky question when we are looking at the UK way of dealing with it. But if we decide before that what we really want, the person we really want to reward here is the person who took the financial risk in carrying out this process, as we did in the case of sound recording, right, the producer, then we can identify or come up with a set of parameters in relation to who is such a person, that is the person who takes the financial risk and makes the investment in the context of an AI system, and define them as beneficiaries. But if we do that, what we have achieved is, first, it doesn't fall into the public domain. We continue to incentivize the creation of works with the assistance or heavy involvement of AI. And we don't, if you would like, corrupt the framework of copyright law as it is today, which makes sense where there is a nexus between the author and the work, a connection, an unsevered connection between them. So so the principle is not being chucked out of the window. That is the necessity for such a connection. Protection is granted, and so incentives continue to exist. I, at least for one, could not identify any significant disadvantage in that result. But there is an interesting conversation that one can have. Let me see here. Another question, one question I have. In case of the monkey and the photographer, should the photographer be given credit for taking an effort in placing the camera? It would be unfair. I think that's a fair point. So a credit, but is what? Now, we can talk about things ethically, but as far as copyright law is concerned, copyright law, as we all know, some of us know, copyright law has two sets of rights, right? Economic rights and moral rights. It is the moral rights that deal with the issue of credit, or the right of paternity, the right of me to be recognized and identified as the author of a work. But this applies only in relation to authors. If that person, right, the photographer, is not recognized as an author, then moral rights do not kick in. So while I accept that it appears to be unfair, that you have done quite a bit of work of teaching the monkey and then placing the camera in his or her hand, and no credit is given to you, as far as copyright law is concerned, you do not deserve such credit because you are not an author. That is not to say that such credit should not be given. I guess, depending on the circumstances, you may have a cause of action here. And again, I didn't explain, it was not an introduction of myself. So I'm a former practitioner. I used to do this for a living for quite a few years as a practitioner. So I'm immediately thinking about other branches of law that may come to assistance here. For example, passing off, right? If the work is produced in such a way where it has been, as though it has dependent on the effort of someone else rather than me, I may, under certain circumstances, come in under the law of passing off and say that there is an actionable misrepresentation. Again, unfair competition in some jurisdictions, civil law jurisdictions, possible. I'm going to take 2 more, and that's it, because I'm getting pings here that I need to get offline. Are there any books that you recommend for us? Yes. I mean, when we start next year, I will give you my recommendations. And the reason why I don't want to do it now is because many times it is August and September when new editions are coming out, and it's always better to get the latest one. But I would say generally both Cornish and Bentley, comprehensive textbook on copyright law, on IP law, are worthwhile. They're not expensive, they are very comprehensive, well written, and fairly, I would say, easily accessible. So, in terms of language and argumentation, they're not heavy, so to speak. Copyright laws granted automatically on creation. Yes, copyright law automatically upon creation. That's what makes this right attractive. Unlike patents and trademarks in that respect, it requires no expense. The only thing, and I will finish with that you are advised to do is keep a record, keep a paper trail that shows that you are the author of that particular work. If people will try to dispute the fact that the title sits with you, and that happens actually quite often. Again, we'll have a chance to talk about that next year. Those of you will join us. It's been a pleasure. It's been fairly quick, but I wish you best of luck with your application process, and we are looking forward to see you all next year. Those of you who will join my modules will have a chance to look at the way IP and technology interact in much more detail. Have a lovely day, and hopefully see you next academic year. Bye-bye.